Hi, thanks for joining us today with Reddy and Neumann. We're doing our usual Tuesday live, answering your questions and giving you the updates on the latest immigration topics, specifically in employment-based immigration. I have with me today Rebecca Chen, who is one of the senior partners in our firm and has been doing immigration longer than I have, so she's the expert. So she will also be able to answer your questions. And today we wanted to talk about the H-1B cap filing window. This is for this year's lottery selections. It's coming up now. The filing window is open. We want to give you some updates on what's going on with that, when is it ending, so you can be prepared. Also, how is USCIS actually processing interfile requests? This is specifically related to people who are upgrading from EB3 into EB2 after they downgraded before. What's the process for that, and how is USCIS, their inner workings of that? We got some information on that last week. And also some information about, what do they expect? What does USCIS expect in terms of which applications are going to be able to get approved before this fiscal year ends on September 30th? And cap gap for F1 holders. If you are having your STEM extension expiring, or your OPT, or even your F1 status is expiring, but you were selected in the lottery, how does that cap gap work once your H-1B petition is selected? All right, so first up, the H-1B cap filing window. Rebecca, when does that officially end?
Yeah, so for this first round, anyone who is selected in March in the H-1B cap, you have to file your H-1B application by June 30th at the latest. If you are someone who wants to take advantage of the cap gap, which we'll discuss a bit later, hopefully you're aware of that, and your actual deadline, if you want to use the cap gap, is a bit earlier potentially than June 30th. But for everyone else, it's June 30th. So it is coming up. We're in the last month of that filing window, and of course it's always better to get the application filed earlier rather than waiting for that last week in case there are unexpected delivery issues, in case there is something that could get the application rejected for some reason, so that you have enough time to refile it. So hopefully anyone who is selected is getting those applications either already filed or about to be filed now.
Yeah, that's really important to not wait till the last minute. I know employees don't have a ton of control over that. It's more based on the company and the attorney. But the earlier you can get it filed, the better, because every year there are many petitions that end up getting rejected. And the rejection notice doesn't come until after the window closes, and then it's too late. You don't have the opportunity to resubmit it. So if something's going to go wrong with the delivery or rejection happens, you want to file early enough to where you actually get notification of that rejection and can hurry up and refile it before June 30th. So that's why that's very important. Rejections can happen for a number of reasons. The petition has to be filed at the right service center. The selection notice actually tells the company where they have to file the petition, so they need to make sure they're sending it to the right place. The start date has to be October 1st, 2022. If they put September 30th by mistake, or if they put October 1st, 2021 because of a typo, can be rejected. If there's any problem with the filing fee check, if they try to combine multiple filing fees into one check, and there's a problem with that, that can cause rejection. If it was selected in the master's cap, but you check the box for the bachelor's cap, it can be rejected. So there's a lot of things that can go wrong. So the earlier you can file, the better, so that if something goes wrong, you have enough time to react and get it resubmitted before June 30th. USCIS, generally, if it's not a USCIS error, they don't let you resubmit it late. So it's this is your last shot with that. All right, on to the interfile request. So we had a USCIS Ombudsman stakeholder engagement last week, where they specifically only talked about employment-based green cards, which I can't recall them ever doing. Yeah. So that was kind of nice that they realized the importance of these green cards, and again reiterated that they're trying to approve them as quickly as they can so they don't waste them like they did last year. But as part of that, they kind of told us what they do with these interfile requests, because it's a new process since January. We've been waiting for receipts all this time. Now we finally are getting them. Some of the interfiles are being approved. So what do? When you send that supplement J to the California address, the file that you sent, the actual mail, gets opened up, they scan it, they upload it electronically into their system, they generate a receipt notice, that's when you get the supplement J receipt, and then they notify the officer that it's electronically available so that they can look at it and decide whether they can adjudicate the case or not. So I think that's really good news, because that tells us they're not gathering it all in California and then shipping it to whatever service center your case may be, or even at a field office. They're actually doing it electronically, which should be helping a lot on that. And also the week before, they told us that they had received 11,000 approximately little packets of Interfile requests at that California address, and by mid-May. They're behind on scanning and uploading. They're about halfway through that. So that does explain why we're seeing such a delay in the Supplement J receipts, as well as not seeing as fast of action as we would have hoped from the Interfile request, but it does seem that they are working on it and picking it up. So that's finally starting to move in the right direction. Also in that same call, they had kind of a Q&A at the end, but they didn't really take any questions from the public. So these were kind of pre-prepared questions. And the person asking the questions basically said, if I have filed a standalone 485 in April of 2022, how likely is it that my 485 can actually be approved by the end of this fiscal year, September 30th, 2022? And the response shockingly said, it is likely to be approved. I was kind of shocked, because as you know, we're seeing people who filed in October 2020 still aren't getting their approvals, but because they're not doing first in, first out. But they seemed pretty confident. So now, what does that mean for people filing in May, or now that we're practically into June? Are they going to get approved that fast? Hard to say, but they did suggest that if you filed standalone, so standalone means your I-140 is already approved, and you're filing a straight 485 with nothing else, no I-140 along with it, not based on a pending I-140. So straight approval where your final action date is current, or you're filing under the filing date chart and the final action date is going to be current. They seemed confident. Yeah, what do you think?
That would be great if that is what they're able to accomplish. Not only any that are filed in April to be approved by September, but hopefully that also includes any that were filed before April and eligible to be approved, that they would get those approved by September 30th as well. Yeah, that would be great if they are able to do it.
They sounded confident, so let's hope that they've come up with lots of different ways to speed up this process, and using the field office and transferring everything to the National Benefit Center. Hopefully that was a good choice for them. Okay, on to cap gap. So can you let us know who's eligible, what has to be in the H-1B petition, what are the timelines for that?
Sure. So the cap gap refers to a situation for F1 visa holders who are using OPT work authorization, who were selected in the March lottery and have their application, like we said before, filed and submitted by the deadline, which is June 30th. However, if their EAD card for their OPT expires sometime before October 1st of this year, without the cap gap provision, then it used to be a situation where your EAD would expire, for example, in July, and that would be the end of your work authorization, not only your work authorization, but potentially your ability to stay in the US until the H-1B goes into effect, because at most you would have a 60-day grace period beyond July to even just be in the US. The cap gap provision, which was put into place several years ago, is kind of a solution to that, where if your OPT expires before October 1st and your H-1B application is timely filed requesting a change of status, so it only applies to a change of status request. It's not applicable if you're planning to file your H-1B petition requesting consular processing. So if it's a change of status, timely filed, then you are eligible for the cap gap, which basically it's an automatic extension of your status and work authorization to September 30th, with the thinking being that if your H-1B is approved by October 1st, then the cap gap will get you to September 30th, and your H-1B will go into effect on October 1st. So there shouldn't be any interruption in your status or work authorization. So that is why it's also important, as we discussed earlier, if anyone has an OPT EAD that expires before June 30th, your personal deadline is going to be whatever your OPT, your EAD end date is. So make sure you are keeping that in mind. Hopefully you have kind of flagged that early on in the process when you were first selected.
And so you said it's automatic, so they don't have to file anything to get it?
That's right. Yeah. So you won't need to apply for another I-765 or get a new EAD card for that, 3 or 4 months to get you to September 30th. It is considered automatic. The way you would document it is a copy of your H-1B receipt notice that shows that you it has a received date before your EAD end date. So that receipt notice plus your expired EAD would be what you need for work authorization for that kind of 3 to 4 month gap.
All right, I think we can go to some questions here.
So Lakshmi from YouTube is asking if I-485 transfers are still happening from the Texas Service Center to the Nebraska Service Center. It sounds like they are still working on those transfers, that they're not entirely done yet. Another thing to keep in mind with the transfers of I-485 from Texas or Nebraska to the National Benefit Center, USCIS did say that when they first announced this transfer that it would only apply to I-485 applications where the I-140 is approved already. So if your I-140 is still pending for some reason, your I-485 won't be transferred. And also your priority date is current according to the final action dates chart, which makes sense because if the date isn't current and your I-140 isn't approved yet, even if it was moved to the National Benefit Center, it would just sit there anyway. It couldn't be approved. So if those two conditions are met, your immigrant petition is approved and your priority date is current, it can be transferred. But it does sound like there are a number of I-485s who meet those conditions that are still not yet transferred or in the process of being transferred.
Vijay from YouTube says, we interfiled and moved to EB2, got the receipt on May 5th, but we don't know if our medicals got attached or not. Should we go and voluntarily file the medicals once again? So I guess my question would be, did you include the medicals in the same package that you sent your supplement J to that specific California address? Because if you did, your medicals are not going to make it into any file because, as I mentioned earlier, that California address, all they do is upload the 485J scan package and let the officer know that it's been submitted. They can't do anything with medicals. They don't open those and upload them or anything like that. So if that's what happened, you need to assume that your medicals are not getting where they need to get, and you need to do a regular interfile, not to the California address, but to the actual place where your 485 is pending. You do still have the option to do that. I'll caution you that in that call last week, USCIS suggested not to interfile medicals because they're moving files around so much, they can't guarantee that they're going to get it into your file. Because you might be sending it to Texas and they've already transferred your file to National Benefit Center, haven't issued that transfer notice yet. So by the time your medical makes it to Texas, your file's no longer there. So they're not going to forward it and it's not going to make it into the file. Now, what you could do is get multiple copies, multiple originals of the medical exam in separate sealed envelopes and try one interfile. If your file got transferred, do another one to the new location and keep one with you in the event of an RFE or a interview so that you've got it covered no matter what. That's one thing you can do with that.
Sarisha from Facebook is asking, so her priority date will be current, it looks like in June, and is asking whether she can both interfile and file a new set of I-485s in the EB2 category because the I-485 was filed based on an EB3 downgrade in October 2020. So there's nothing stopping you from doing that, from both interfiling and refiling, but it may not be necessary. Usually when you are interfiling will essentially convert your existing EB3 I-485 application into an EB2 when the interfile actually goes through and gets updated to the file. And so if you also at the same time file a new set of I-485s in the EB2 category, you'll basically have two applications, both in the EB2 category, which is not, there isn't anything wrong with that necessarily, but it may not be needed. You know, we've been talking a lot about whether it's better to interfile or refile. If at this point right now in the fiscal year, it's a bit hard to say because we know that USCIS's goal is to approve as many as they can by September 30th. We don't know if any brand new applications, I-485 applications that are being filed standalone right now, as we discussed earlier. We don't know if those will necessarily get approved by September 30th. I would lean more towards an interfile being successful at this point, since it sounds like they are kind of at least getting in the groove of scanning them, receiving them, getting them matched up to the file. So if you were to do one, I would probably lean more towards interfiling right now, although it doesn't damage anything to also refile. It just may not be necessary.
Second of all, from Facebook says, what would happen if I leave the USA while the 485 is pending and the AP is pending? Received the EAD only. I'm working on the 485 EAD. Can I enter on H4 for my wife and H-1B for me and then continue to work on the 485 EAD? That will not work. So there's two ways that you can travel when you have a pending 485 and you're an H or L visa holder. The first way is to wait for the advanced parole, travel, and come back on advanced parole. The other way works only if you're already in H or L status at the time you leave and you're coming back in the same H or L status. In your case, because you've used the EAD already, neither of you are in H or L status anymore. You're in adjustment of status. So when you leave, because you were not in H or L status at the time you left and you don't have an advanced parole, your 485, the whole thing will be abandoned and denied. Not just the AP, but the whole 485. So you have to wait until you get the AP approved before you travel. You may want to try and expedite if you have an urgent need to travel, or possibly litigate it. If it's been pending for more than 6 months, then you need to travel urgently.
There's a question about the processing times at the Texas Service Center increasing from 15 months to 33 months. And yeah, that is something that has been observed recently, kind of seemingly erratic increases in processing times on their new case status website, or processing time website on the USCIS page. So that was also addressed somewhat in the stakeholders meeting last week, because the I-485s, as we mentioned earlier, are being transferred if they are eligible to be approved. They're being transferred from Texas and Nebraska to the National Benefit Center. It sounds like the I-485 processing times that are being listed now for Texas and Nebraska are based on I-485 cases that are still there, which, as we said earlier, are those that either the I-140 is not yet approved, or the priority date is not yet current, or there is something else holding up the application to where it cannot be approved. So that 33-month processing time seems to be based more on sort of these outlier cases rather than the normal processing time if you have a receipt notice with SRC or LIN. Because if it's ready to be approved, in those cases, yours will be at the National Benefit Center. So the Texas processing time won't really apply to your case anymore.
Robbie Kieran says, my priority date became current in December 2021. If I can't apply for the 485 within 1 year because the GC process is still being transferred to the current company in EB2, can I apply for the 485 in EB3 since it's not current and I have that with my previous employer? Well, you don't really need to do that. This whole 1 year rule is not relevant to adjustment of status filings. It is relevant if you're consular processing. So if your final action date is current and you've consular processed, the NVC has reached out to you to start the process and they don't hear from you within 1 year, they will terminate your green card process at the consulate. That is not applicable to 485 filing, adjustment of status in the US. Whenever your date is current, whenever you get that new I-140, even if your date has been current for 5 years, you can still file the 485 as long as you've continued to maintain your non-immigrant status and are eligible for adjustment of status. So there is no 1 year rule that the whole thing cancels if you don't file within 1 year. Where the 1 year does become relevant is for you to keep getting H-1B extensions beyond the 6 year limit. Because for that, when your final action date is current, you can only get 1 year extensions of the H-1B, not the 3 year extensions that everybody's been getting for the past several years based on an approved I-140. Then, once your date has been current for more than a year, it's up to the discretion of USCIS whether they will allow you to keep extending in 1 year increments when you still have not filed the 485. They have been approving those types of applications, and really what you could do in your situation is use your EB3 I-140 approval where the date is not current to keep extending your H-1B in 3 year increments. And then once you have your EB2 I-140 approved with a new company, you file the 485. No issues at all, even if it's been more than a year since the EB2 date became current.
John from Facebook is asking if you need to be in non-immigrant status in order to refile an advanced parole application, to refile an I-131. This might be a situation where potentially they departed the U.S. while the first I-131 was pending, and as we've discussed in the past, departing while an I-131 is pending and not yet approved could result in the I-131 being denied. So if that's the case, or if you're just trying to refile the advanced parole because of travel just to be safe, you don't need to be in an underlying non-immigrant visa status in order to just submit another I-131 application. So you do need to be in valid non-immigrant status in order to refile an I-485 application with that might have an accompanying I-765 and I-131 application. So you do need to be in valid status to do that, to refile an I-485. But just to resubmit an I-131 application, it's only required that you be here physically in the U.S. and that the I-485 application still be pending. So as long as that's the case, you can definitely file the I-131.
Vijay has a common issue that we're seeing right now. He's got the online case status all of a sudden saying your case remains pending. We're temporarily pausing work on your application because an immigrant visa number is not immediately available. Once it becomes immediately available, we will resume processing of your application. But of course, this is a case where he's already interfiled from EB3 to EB2, where the date is current, and gotten the Supplement J receipt notice. So what is USCIS doing? We have been seeing this for the last several weeks, and we don't have an answer for you as far as what we need to do. It's possible we don't need to do anything, that once the officer gets notified that your 485J has requested to transfer the underlying basis, the officer will see that and start adjudicating the case, and then it will continue to process even though they put that status online. We're not sure exactly why they're doing that or how do we get them to stop doing that. We haven't figured that out yet. But it is common. We're seeing it quite a few cases, even where they already issued the 485J receipt for EB2.
Romilly from YouTube is asking about her parent who in 2020 was stuck here in the US like a lot of people, a lot of travelers or visitors, and applied for a B2 extension because she wasn't able to depart the US in 2020. But then the I-539 didn't get approved because she ended up departing before the I-539 could be fully processed, which was very common for a lot of people during that time who applied for an extension of their visitor visa. And will she now have any problem coming back to the US on that same B1, B2 visa? There should not be any problem as long as the important document that your parent will need to re-enter the US is the I-539 receipt notice that shows that the extension application was filed before her prior 6-month I-94 expired back in 2020. From our observation, or what we've been hearing, is that CBP hasn't been giving people trouble about re-entering in that situation because it was, widespread knowledge that a lot of people had to apply for that extension, and they're aware also that I-539 processing times were, way more than the 6 months that that you would have requested in the extension. And so a lot of people did the exact same thing, departed before it got approved. And so far we haven't heard of that many issues with CBP coming back on the same B1, B2 visa. We have heard of a couple of instances where people were questioned. And so I know that Rahul in the past has advised that if you want to be extra safe, you can apply for a new B1, B2 visa with the consulate. And right now, since to the end of 2022, there is the expanded Dropbox provisions that make applying for any visa renewal easier. You might want to take advantage of doing that if you want to take the extra step and be safe. But I would say if the I-539 was filed before the I-94 expired back in 2020, and you have that receipt notice, that should be enough.
Bob has written letters to a senator and congressman. Thank you for that. And he said he refiled in early May and got the receipt numbers in a week from Emma, but he did not receive the 485J receipt. Is that a concern? No concern at all. That's very common. A lot of times we don't get a 485J receipt until the end of the process when they're ready to approve the green card. We saw that really starting in probably October 2020 with all of those filings. So no cause for concern at all.
Venkata from Facebook is asking about her child's I-485 application, which was submitted in EB3, and her age was locked in under CISPA when the EB3 I-485 was filed. And if they interfile now to EB2, will that affect anything? So your child's age will still be considered locked in, even if you interfile to EB2 right now, as long as the priority date was current under the final action dates chart in the month where your I-485 was initially filed. Then your child's age remains locked, even if the dates retrogress after that, or you interfile to EB2, so that should be fine.
Santosh says, my company attorney is filing the ETA 9089 with additional responsibilities. I already have an approved I-140 in EB2, which is current for June. Is it a good idea to submit a new 9089 at this time, which has no premium processing? It all depends ultimately on whether the job offer that supports your EB2 I-140 is still available or not. So when you say I'm assuming you mean they're filing a new perm because some change to your job has occurred. If that change is a material change to where you can't say that the job offer is still valid and they're only offering you this new job, then you do have to go through that whole perm process again and wait until that gets approved before you can file your I-140 and 485 together, assuming the date remains current. But if that old job is still available, or if the job has not changed so much to where it's a material change, you may be able to proceed with the EB2 I-140 that you already have. I think a lot of it depends on what's changed within the job, but it's very much dependent on the attorney. Some attorneys say, oh, any change in the job between the time we filed the perm and the time you're filing your 485, nope, we've got to start the whole process over again, which is not really true. I think sometimes that can help generate some additional fees because you get to file a whole perm all over again. But a lot of times it's not necessary to do that if it's not a material change. If the salary has increased over the last 10 years, that's pretty normal. Someone would expect that to happen. If the work location, the company moved from one block to the next block, that's normal for that to happen, and that's not a material change because it's within the same area. Now, if the job changed from California to New York and the California office closed, that job's no longer available, that's the kind of situation where a new perm has to be done and you don't have that choice of using the old EB2 I-140.
Ankit and his wife have I-485 applications pending where his wife is the principal applicant and he is the derivative, and it's filed in EB3, and he's asking if his employer can file an EB2 for him as the principal with his wife as the dependent. So yes, you can definitely do that. We've had a lot of cases where both spouses have their own I-140 approved with their own employer, and they each file an I-45 as a principal with the other spouse as a dependent. So there's no problem with that, and it gives you an advantage because you have more than one application in different categories pending, and whichever becomes current first or can be processed first can get approved for both of you. And then the other remaining applications that are still pending will just sort of be administratively closed on their own. So there's no problem with that, although I would say that in your wife's case, if her priority date is becoming current in June next year, you may want to consider interfiling from EB3 to EB2. As we mentioned earlier, USCIS's goal is to try to approve as many as they can by September 30th, and if you have not already interfiled to EB2 for your wife's case, that may end up being faster for both of you than refiling a new set in EB2 under your employer, although there's no harm in, you could also do both.
Avinadan says, what is the approximate timeline for processing a 485 at the National Benefit Center if it's filed in April 2022, standalone, EB2, July 2014 priority date? Biometrics were already received for June. You know, based on some of the approvals we're seeing, based on what USCIS said in that stakeholder engagement last week, it could be 5 or 6 months, meaning you should get it by the end of the fiscal year, September 30th, 2022. Could it take longer than that? Are we seeing applications take longer than that? Definitely. So I'd say it could be anywhere from 5 months to probably 18 months. It might not be until next fiscal year, just depending on how USCIS processes these. And there's no rhyme or reason to it from what we can tell. It's just all over the board.
Imran is asking what would be the consequences of him changing employers after less than 180 days after he has submitted an interfile request to move from EB3 to EB2. So the guidance from USCIS on their website, at least, is that filing a request to transfer the underlying basis of your application from EB3 to EB2 basically restarts the 180-day AC21 clock. Basically, you would need to wait 180 days from the I-485J supplements receipt date to safely change to another employer. It's a bit questionable, and we've spoken about it in these sessions before, kind of questioning whether that is really necessary to wait another 180 days when your I-485 was likely filed much earlier than that, probably from 2020. We are still kind of waiting to see the results of those situations. We know people have tried doing that, changing employers before the new 180-day clock that USCIS seems to require. Since in the AC21 regulations, it doesn't mention anything about waiting another, restarting the clock based on a J supplement filing. So there's an argument to be made that it's not necessary to wait 180 days, although we don't have results on that exact situation just yet. Our estimate is that worst case scenario, if USCIS really sticks to the guidance they published on their website and do require the 180 days, the worst that could happen most likely is that they would just process your I-485 in the EB3 category rather than EB2, basically not allow you to interfile, although like we said, we're still waiting on those results. We don't think USCIS would outright deny the I-485 entirely.
Kind of along those same lines, Mama Pova says my priority date's June 2014, and I changed employers after filing the 485 EB3. Now that employer is not willing to file an EB2. May I file the 485 in EB2 using the 485J and AC21 through the current employer? So I don't think you can file a new 485 based on a supplement J that's signed by the new employer. The new employer first has to go through the PERM process and get that I-140 under their name before you'd be eligible to file a new 485 based on that company's job offer. What we don't know is, can you interfile using a new company's job offer and your old company's EB2 I-140 approval notice? I think technically the answer should be no, you should not be allowed to do that. I think people are trying it. I've responded to an RFE attempting it, haven't gotten the result of that yet. I know some people have done interfiles in that situation and gotten it approved, but I do think there's risk there that they might not accept it. But worst case scenario, you're looking at being stuck in EB3 in that situation until your new employer gets a new perm and new I-140 on your behalf.
Vidon is asking, is it necessary to have a master's degree or a bachelor's degree plus 5 years of experience in order to qualify for the EB2 category? So those are the most common ways I would say that people get classified in the EB2 category, but there is another option called exceptional ability under the EB2 category that does not require a university degree. So that depends more on kind of a subjective analysis of a little bit similar to extraordinary ability for O1s, although not quite as high of a standard for, so it's called exceptional ability. There's a list of about 6 potential criteria, out of which I think you need to qualify for 3 that include things like significant accomplishments in your field. You usually need, letters of recommendation from notable people in your field, or having a higher than normal salary for that occupation, kind of different criteria that if in the aggregate you can make an argument that you meet the standard of exceptional ability that's defined, then you could potentially qualify for the EB2 category without having a degree.
Junaid says, do we need to amend the H-1B, refile the perm and the I-140 and a supplement J if there's a merger of the current organization and it's registered as a new company? Short answer, it depends. So let's assume that this type of merger qualifies as a successor in interest situation. When the new company is a successor in interest, it is not required to amend the H-1B to get it in the new company's name. The H-1B continues to be valid as long as the new company is offering you the same job, same location, same salary, all the same terms and conditions of your previous company's H-1B. They do need to update their public access file. That's the company's responsibility to do, but they don't have to file anything H-1B when they're a successor in interest. Same thing, assuming your perm has been approved, your I-140 has been approved, and your 485 has been filed and pending for 180 days, you could not file a new perm or new I-140 and instead use AC-21 to transfer your pending 485 to the new entity, regardless of whether they're a successor in interest or not. That's one option. But if you have not filed your 485 yet, and you have your perm and I-140 approved, and the company is a successor in interest, they are required to file an I-140 amendment, letting the Immigration Service know that they are a successor in interest, providing the documentation, showing that they're offering you the same position that was on your original labor certification, and confirming they have the ability to pay the salary offer. So those are all the different scenarios that could come up, assuming that it is a successor in interest.
Ravi Kumar is asking if he thinks if we think there will be a second round of H-1B lottery selections this year. So the last 2 years, there have been additional rounds of selections. In 2020, there was 1 additional round in late summer. Last year, there were 2 additional rounds of selections. And I believe the data that we received from AILA, or that USCIS released to AILA, was that last year there were a total of over 130,000 registrations that they selected cumulatively among those 3 rounds to actually receive the 85,000 petitions that they needed to fulfill the quota. So that indicates that there were a lot more applications than USCIS expected, or registrations that didn't get petitions filed based on the selection than USCIS expected. So we don't know if that means that this year, with over 400,000 initial registrations, maybe USCIS is going to adjust kind of preemptively, and maybe they have already selected in this first round in March a lot more than they did in the previous 2 Marches. If they selected the same number that they have in the first rounds the last 2 years, then I would say it is pretty likely there will be at least a second round of selections in August, like we saw the last 2 years, but USCIS has not said one way or the other quite yet.
The note says his daughter's not a U.S. citizen. Which option will prevent her from aging out when she turns 21? Interfiling to EB2 or refiling in EB2? The difference between interfiling and refiling doesn't change anything. So both options will work, assuming that she meets the requirements for her age to be locked based on EB2. So we need to know, is the final action date current in EB2, and is she under 21 based on that? Then whether you interfile or refile, either of those will lock in her age. If the filing date is current, and again, this is assuming the I-140 is approved as well. If the filing date is a current, not the final action date, then her age does not get locked simply by interfiling or refiling. It's only going to be locked once the final action date becomes current. So you need to time out how much time she has before she turns 21 compared to when you expect the final action date to be current, and then decide whether there's enough time to lock in her age before she turns 21.
Chan from YouTube had an H-1B and H-4 extension approved this year, valid until 2025, and then traveled to Canada and came back in with an expired visa stamp and asking, is the I-94 attached to the I-797 approval notice still valid? So actually every time that you re-enter the US, you should receive a new I-94. The problem is that it's not very well publicized where you find this I-94, I think by CBP. It is a bit confusing because you have the I-797 with the I-94 card attached, which is physical, but at each entry you are issued a I-94 record that the way you access it is to go to CBP's I-94 website and enter your passport details, and it will pull up the record, and it lists on there your most recent date of entry, the class of admission, and the validity period that you've been admitted for. So actually that I-94 kind of supersedes the I-797 I-94. And it's important to check that I-94 record online after each entry into the US because it will generate a new I-94, or it should. And that I-94 now controls your status in the US from your most recent entry. And it should match the end date that's on your I-797 approval notice, so hopefully it does. Online it also says 2025, but CBP officers have made mistakes in the past, and sometimes it gets cut off earlier than expected, or sometimes the I-94 electronically gets cut off because the CBP officer issues the end date not based on the I-797 approval notice, but based on your passport expiration date if it is earlier than the I-797 approval notice. So that's something pretty important to look out for. Just make sure you check your I-94 online. That's the one that controls your status currently.
AJ says, my wife is the primary applicant for our 485 applications. We did the interfile request at the Nebraska Service Center, and she needs to quit her job. Can I file now another 485 as the primary and her as the dependent, because my priority date is also current? Yes, you can do that, assuming that you both have continued to maintain your non-immigrant status even after filing the first 485. But yes, you can have one pending where she's the primary and you're the derivative, and you can have a second one pending where you're the primary and she's the derivative, and assume that maybe the first one is no longer going to be approved because she's quit that job. Then you can rely on the second one instead.
Minute from YouTube is asking about a medical exam that he got an RFE for in connection with his I-485, even though he already submitted the medical exam with the initial I-485 application, and asking whether he needs to get a new medical exam or if he can submit the same previous one. So it's not really clear why you got an RFE. If you did submit the medical exam before, there's a possibility that maybe the medical that you submitted back in September was deficient for some reason, if the physician didn't sign the I-693 form, or So there is a rule that the medical exam, the form, needs to be submitted to USCIS within 60 days of the physician signing it. So we know there's been kind of some misunderstanding of that, because a lot of people say, oh, your medical exam is valid for 2 years. That is the case once the medical exam is accepted by USCIS. But after the physician actually does the exam, from the date of their signature, I believe it needs to be received by USCIS within 60 days. So that might be one reason why you got the RFE, if it was maybe longer than 60 days since the doctor signed it by the time you were able to submit it with the I-485 application. Either way, at this point with your RFE, I would definitely get a new exam. You won't be able to submit the one from last year because it's been longer than 60 days. Hopefully you can speak to the same physician who did the exam before and see if they will maybe get a discount on doing a new exam, but it will need to be a new exam with a recent signature by the doctor.
Sumant says, my EB2 I-140 was filed by Company A back in 2013. That company was acquired by Company B, and I downgraded to EB3 in October 2020 with that I-140 in Company B. Now my EB2 is current. Do I have to amend my EB2 I-140 since the petitioner on that is Company A? Yes, you do. So I'm assuming when the downgrade was filed, it was done as an amendment, which it properly should have been. Not all downgrades should be amendments, but when it's a successor and interest situation, the downgrade is supposed to be an amendment. And that downgrade filed as an amendment actually means your EB2 currently does not exist. So you do have to file another amendment using the same labor certification to get back into EB2 to be able to interfile or refile.
A question from YouTube from someone who was previously in H-1B status, departed, and after 8 months came back in on F1 and is on OPT currently, and is asking whether his employer can file an H-1B application for him now, even though he was outside for less than 1 year. So one thing to keep in mind, if you had maxed out of your previous H-1B 6-year limit when you departed the US previously and you had no time left in that 6-year limit, then yes, the rule is that in order to get a new 6-year period on H-1B status, you have to have been physically outside the US for 1 full year. It doesn't count if it's been over 1 year now, but you since entered the US before 1 year was up in a different visa status. So if that is the case and you're looking for a new 6-year term, you do have to have been outside the US for 1 continuous year, and then the employer has to submit you in the lottery again in March in order to make you eligible for a new term. If you did not use up all of your 6-year period before, and you have, even a few months left in your 6-year period, an employer can file for a change of status for you now from F1 to H-1B without going through the lottery if you have any time left to recapture from your previous stay in H-1B status. It would be best if it's not very much time. Hopefully the employer has or is willing to start the green card process for you so that you can get an I-140 approval to extend it beyond the amount of time you have left. But that is doable if you haven't maxed out already.
Keishore says, my GC is approved. My wife is currently on H4 and her 485 is still pending. Her EAD is also pending. What happens with her status now? Yeah, we're seeing a lot of that these days where one person gets the approval and the other one continues to be pending. Sometimes it just takes some time. Maybe the files got separated. Other times there's an issue in the second case that causes a delay. They eventually get the approval. But in terms of status, since you received your green card, that means you're no longer in H-1B status, which means she's no longer actually in H-4 status. She's now in what we call adjustment of status, which is a lawful stay, and she is not able to work using her H-4 EAD if she had one because she's no longer in H-4, so she can't work until she gets the green card EAD or the green card itself. But she is lawfully able to stay in the US in adjustment of status. She just needs the EAD to work, and then if she does need to travel, she's going to have to get an AP to do that. She can't use the H-4 anymore.
Bihari is asking what does USCIS do when your final action date becomes current for an application that was filed when the filing dates were current and your biometrics are done, your medical is submitted? So technically you should not really need to do anything at this point if the underlying immigrant petition, the I-140, is already approved and you've done your biometrics, submitted your medicals, and your priority date is now current according to Chart A, or will be most likely starting in June. You should not need to do anything. USCIS is supposed to be aware that your priority date is current or a visa number is available for your case, and they should just approve it. Hopefully that is what they do. Hopefully the case is that if your I-45 was pending at the Nebraska or Texas service centers, that sometime in June, if that's when your priority date is becoming current, you would receive an I-45 transfer notice notifying you that your case is being transferred to the National Benefits Center. That is kind of a good sign that USCIS is aware that your case can be approved and is transferring it to approve it, but you don't need to do anything on your side to activate that.
Mohammed says the I-140 has been approved, but my employer is not sharing the details. How can I get the details? You can do a Freedom of Information Act request, or FOIA or FOIA, of USCIS and ask them for a copy of your I-140 petition filing, and you'll get the actual I-140 forms, and you'll get most of the supporting documents that were submitted with it, along with your labor certification. You don't have to go through your employer for that. The employer is not going to be aware that you've done it. If you Google FOIA USCIS, it will take you to USCIS's website where you can actually fill out the FOIA request online using your My USCIS account, which I highly recommend it. It's much faster than mailing in anything. And it's usually just taking a few weeks to get that, but just follow the prompts for the information that they ask you for, and they'll be able to send you a copy of that, usually electronically.
Himanshu Kumar is asking if he can upgrade from EB3 to EB2. It sounds like he has an EB3 I-140 approved, but has never had an EB2 approval, but qualifies now for the EB2 category. Most likely, maybe you have now 5 years of qualifying experience that you can add to a bachelor's degree to qualify for the EB2 category. And if that's the case, then yes, you can qualify for EB2, but it does require, if your underlying perm application that was the basis for your I-140 approval, your EB3 I-140, if that perm was filed such that it only required a bachelor's, basically the perm was filed in EB3, you won't unfortunately be able to use that same perm to support a new EB2 I-140 application, even if you now qualify for EB2. It would basically require your employer to file a new perm on your behalf that's in the EB2 category, and then file the I-140 based on that. And with perm processing being what it is right now, you mentioned that your employer said it could take 2 years. That's not far off. At the quickest, it would be, probably 12 to 16 months with the amount of time the prevailing wage determination is taking, and then the final processing for the perm application.
Gotham says, my current work location is Pennsylvania and my perm is in progress. If I move to California and work for the same employer, do we need to file the perm again? Maybe. It depends on whether the move is temporary or permanent. So assuming that you're temporarily moving to California, but your job offer in Pennsylvania is still there waiting for you and you could go back to it, then no, a new perm is not required as long as that job offer remains in Pennsylvania for you to take when you get your green card, even though you're currently in California. If the opposite is true, to where everything is moving to California and the job in Pennsylvania is going away, either because the company is no longer going to have an office there or that job is just being relocated to California, then it does require a new perm process, because the work location, the labor market has to be tested in the actual work location. So they may have to do advertising in California instead of Pennsylvania in order to check if there are US workers available.
Sri is asking if a promotion will affect his pending I-140 and I-45 applications. He has one each in the EB2 and EB3 categories, it sounds like, and is being promoted from manager of analytics to director of analytics. So this is pretty similar to the earlier question along those same lines. It's kind of a matter of how comfortable the company and attorney are, but I would say that a promotion like that sounds like it is similar enough that it would not require a new perm unless for some reason that promotion is altering the essential role, that it can't really be described anymore by the SOC code listed in your perm or the job duties described in your original perm form. But from those titles, it sounds like they're both managerial and that it's in the same technical area. So it sounds close enough to me that it should not affect your pending I-485 applications.
Evelyn says, I have to travel to India and return on June 24th. My visa stamp will expire June 26th, 2 days later. If I don't get the Dropbox appointment, can I still travel and return safely? So I'm going to assume that you've already extended your status with USCIS beyond June 26th. So you have that approval notice. When you're coming back in, you just need the visa to be valid on the day you're entering. So the fact that it's expiring 2 days later should be completely irrelevant, especially where you've already extended your status with USCIS. So you can show them the valid visa stamp, even though it's expiring in 2 days, plus your extended I-797 that has a valid I-94 attached to it, and you should be able to travel in that situation.
Bharat is saying that his company's lawyers are saying that you shouldn't have more than one I-485 filed and pending. This is a situation where he and his spouse each have an I-140, kind of like we discussed before, and wanting to know if they can file. Each files a principal with each other as a dependent or a derivative. There is no problem with that in our experience as far as it delaying or confusing USCIS. We've had a number of cases where the I-485 gets approved, even though there was more than one filed and pending. We did a lot of those last year where a refile in EB2 was done and got approved without a problem. I would say several years ago, it might have been the case that USCIS would send an RFE if you had more than one pending I-485, asking you to basically choose which one that you wanted to go with. But I think in the recent ones that we've had, that we've seen approved, there wasn't an RFE sent like that. USCIS pretty much just administratively closed on their own the other I-485 application that was not ready to be approved. So we don't think that there is any problem with that.
Let's see here. One last question. This is from Radhakanta. The perm was filed in December 2021 due to personal circumstances, moving back to India in July. While I'm in India, can the I-140 be filed? My H-1B is maxing out in January 2023. Yes, absolutely. Neither the perm or the I-140 require your physical presence in the US. The company can sponsor you regardless of where you're located. We don't even submit status documents with an I-140 petition. All we show is that you have the required education and that you have the required experience, that you have the labor certification approved, and that the company has the ability to pay your salary. Your status is not questioned at all for that, so no problem there. All right, well, that leaves us out of time for today. Thanks so much for joining us, and thanks, Rebecca, for giving us your expertise today. If you didn't get your questions answered, remember we do have a daily conference call that you can join by going to rnlawgroup.com, and you can get the details for that. And don't forget to subscribe to our newsletter also at rnlawgroup.com.